Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. I've received some feedback which I very much welcome from our listeners of the Indie Zone podcast and also to our followers here on YouTube, inquiring about when the next hearing is scheduled to occur in Idaho versus Kohberger. As of right now, there has not been any ruling by Judge Hippler whether the court will grant Mr. Kohberger's motion for a Franks hearing. That matter was filed back in November, along with the 14 motions to suppress evidence. There were hearings that occurred January 23rd and 24th. At this time, and this is early in the day, on the 6th of February 2025, there have been no rulings on the motion for the Franks hearing, nor any rulings on the motions to suppress. So we will wait word from Judge Hippler as to whether or not Mr. Kohberger will be granted that Franks hearing. So let's put that matter aside. The next item that is set to be entertained by Judge Stephen J. Hippler can be found on the case summary page for the Idaho versus Kohberger case. This is a very helpful tool. It is maintained by the clerk of court, and it documents key events in the case chronologically. Any motions that have been filed, responses, replies, those are the briefings, as well as hearings that have occurred in the past and what's set to occur in the future leading up to the summer of 2025 when Mr. Kohberger is set to go to trial in this case. And want to always state that Mr. Kohberger is considered innocent of the charges that have been brought against him until or unless he is either adjudicated guilty at trial or he pleads guilty. That's in our Constitution. If we look at the case summary page, which is the first item, there's a hot link listed under the case style for Idaho versus Kohberger on the Idaho Court's Cases of Judicial Interest website that you can access by following this link. We see that the clerk has been very busy in this case. There are a total of 69 pages that comprise the case summary page at this time, and this will only get larger as the days and weeks and couple of months now pass, getting closer to the trial. But if we go on the case summary page to the top of page 69, the third item down is a motion hearing that is set to start at 9 o'clock a.m. The judicial officer is Stephen Hippler. When you look at this case summary page, just above it, you'll see a couple of canceled hearings that were supposed to occur before Judge John Judge. He was the prior judicial officer who presided over this case before the transfer of venue happened from Latah to Ada County as it did last fall. So you're going to see some canceled notations here. You're always going to want to make sure that what you're looking at is a matter before Judge Hippler. That tells you also what's coming up. For example, there's also a motion hearing that's set for April 16th, pretrial conference, and other related matters. And you can learn more about what this means by looking at Judge Hippler's pretrial and trial order that we're going to refer to here in just a second. But going back to this item here, we see that the very next thing, and we can confirm it by looking at everything between today, which is the 6th of February 2025. There's a couple of notations for February 6th. There is no hearing for today. This is a canceled motion to suppress hearing that was to be held before Judge John Judge, and also canceled motions in limine hearing before Judge John Judge that would have happened March 27th, 2025. So we see the last filing was the intent to use IRE 404B evidence, filed February 4th, 2025. As of right now, there is nothing between the 6th of February and the date of the motions hearing coming up on April 9th, 2025. So, what I encourage you to do also is to look at the blueprint for everything that will be happening in this case. It is Judge Stephen Hippler's October 9th, 2025 order. And it lists all of the key events that are happening pre-trial, which is right now, that have just happened, and that will be happening in the case, leading up to, as it says here on page 1, what I believe is the official start of the trial, not August 11th, but July 30th, because that is when Voir Dire, which is the process of jury selection, that is necessary because this is not a bench trial. It's not a trial where Judge Hippler is going to be looking at the evidence and determining guilty or not guilty. It is a jury who will be doing that. Jury trial cannot happen without the jury. Hence, my personal opinion that the official start of the trial is July 30th. Page 2 has all of the motions and some other related matters, deadlines for certain motions, such as the motions to suppress, the motions to compel discovery, the motions to set aside the DP. All of these things have happened. We're waiting for rulings, as I've said, on the 14 motions to suppress evidence. Motion in limine was also addressed on this pretrial order, but there was something that happened. The parties went to the court and asked for an extension of time as to when the motions in limine responses and replies are due. Judge Hippler granted that request, and so per the court's order, the motions in limine are due from both sides the 24th of February. The responses in opposition from both sides are due the 17th of March. And then the replies, the 3rd, are due on March 24th, again, 2025. And then finally, you see, this is the April 9th hearing. This is the hearing on the motions in limine, and Judge Hippler has done exactly what he did for the motions to suppress. He has set aside a second day. If necessary, they will continue on. The oral argument will continue on into the 10th of April, 2025. One more thing that I wanted to point out in looking at this schedule. When you hear briefings, the briefings are the motions, application for a court order, here, motions in limine from both sides, due the same day, simultaneously, 24th of February, coming up here rather shortly. The response in opposition, both sides, the 17th of March, and then the replies, both sides, the 24th of March. That's the pleadings. Motion, response, reply. Unless something happens, someone asks for leave of court to amend or to add something on, pleadings closed, and then there's going to be a hearing, oral argument. Sometimes the court will rule on the papers. The parties will agree that no hearing is necessary. But for certain motions, something as crucial, especially as motions in limine, Court's already set aside 2 days. But in any event, simultaneously, what does this mean? Both parties file their motions in limine. So you may have a motion in limine from the state and a motion in limine from the defense. The response in opposition is going to be the state's response in opposition to the defense's motion in limine. Same with the defense. Their response is going to be in opposition to the state's motion in limine. And then the replies, both sides file simultaneously their replies to the responses. And a reply is supposed to be constrained to just filing something rebutting what is in the response, not allowing a second bite of the apple where people go and they argue their entire motion again. If you would like to take a look at the case summary page, and I do recommend that you do, please follow this link that I have provided here in the presentation. It's also in the description to this presentation. And you can also look at the filings that we have addressed here, the pretrial and trial order, the schedule for the motions in limine and other related matters, by also following that same link. And if you have any comments, questions, feedback, please leave it here. Subscriptions to the channel are greatly appreciated. If you like our content, please do subscribe to the channel. This is Kathy. Thank you for joining us here today.